Now we start the second session. Madam Priyanka, you present your presentation up to 4 p.m. Now, Madam Priyanka Chakraborty.
Thank you so much, sir. Welcome back, everyone. I hope you all had a very hearty lunch and are refreshed. So before we went into this lunch break, I had given all of you a bit of a assignment, if I can say that. So I hope all of you have written your open statements for yourself. And I would just request any one of you to just, probably present your opening statement. Any one of you who would want to volunteer and, read your opening statement to all of us here. That would be great.
Sir, Madam, should I start?
Please, sir, please go ahead.
Yeah. My name is Arup Ratan Saha. I'm working as a faculty member of the Department of Law, Cox's Bazar International University. Let me start. Good afternoon, everyone. I am Arup Ratan Saha. I'll be serving as your mediator. You may call me by my last name, Mr. Saha. Mrs. Sheena, do you mind if I call you Miss Sheena? Thank you. I have heard that you are an excellent homemaker and an entrepreneur. You have been running your tiffin services for the last half a decade. That is excellent. Do you mind if I call Professor Akhtar? Do you mind if I call Professor Akhtar? Thank you. Professor, you are a professor in the Bengali literature at University of Dhaka. I know you from your excellent write-ups in Bengali literature. Thank you, both of you, for coming to me. You two have two wonderful children, Shoaib and Sana. Hello, little masters. Shoaib and Sana, I have bought some chocolates for both of you. And you have a puppy called Sheru. As I have heard that you are in a relation for the last 10 years, and in this stage, you have some issues which needs to be resolved. Just to make you clear, the purpose of this meeting is to help you work out an understanding which should be acceptable to both of you in order to resolve the issues we have at hand. First, I am just briefly explain you how we are going to proceed with this. We will begin by asking each of you to explain to us exactly how you view the entire situation. I will try to understand the situation, putting myself in your shoes. Later on, we can identify what are the disagreements. After that, we will work together and try to find out what do you want from each other and what are the possible solutions might be. Let me clear one more thing to you, that my goal here is to find out your own solution of this problem. I won't be telling you what to do, neither I will judge what is right and what is wrong. This is your life. You will be living with this solution. I assure you that anything you say during this conversation will be completely confidential. We will note, but when we finish this, I will destroy everything. And feel free to take any break. For an example, if you feel really upset, if you are getting really emotional, and if you want to take time out, you can feel free to ask me to have a time out. And lastly, I ask you to agree not to interrupt when the other person is speaking. Thank you.
Okay. Okay, that's great. I think Professor Saha, that would be right. So that's a great attempt, Mr. Saha. So I would want to point out a couple of things, and this is exactly why I wanted you to do this, all of you to do this practice, because it's one thing to hear it in theory, and it's a completely different thing when it comes to practice. So when you started with opening statement, you started introducing the other parties, and while saying that, you appreciated both the parties, and I understand you tried to be balanced. But when you were mentioning the husband's credentials, you said that I know you from the articles you have published and I have read them. So the moment you say that, you are sort of referring that you are an academic fan of the person. So you could be biased. Okay, if I was the wife there, I could have felt that, you know, আপনি তো আগে থেকেই আমার স্বামীকে চেনেন, আপনি ওনার আর্টিকেল পড়েছেন, তো obviously you will support him, right? So that is number to point out. Now, if I'll tell you honestly, this entire problem that I shared with all of you has nothing to do with your opening statement. Okay, it has nothing to do. I just shared because this is exactly what I was sure would happen, you know, because you will pick up on the story and you will try to make the facts, but opening statement has nothing to do with it. Okay, opening statement, and I can tell you this, with practice, okay, you will have one fixed opening statement for yourself, which you will like literally follow in all of your mediations like a Bible. Okay. Now, the second thing that I want to point out and I want to appreciate is you took out time to a bit of yourself to, you know, talk about yourself. You introduced yourself. That is very good. Okay. That is you have to do. Okay. So you have to introduce yourself first. Like you said, I am so and this is my work and this has been my experience. You say that to build trust for both the parties. Okay. And you say, I welcome both party A and party B to the mediation. That is it. How you are going to address them is something you ask in welcome. While you are welcoming the parties into the room, that is when you ask, not in your opening statement. Okay. Then going henceforth, please don't take it as a criticism or anything. This is a very good learning base for everyone. Okay. And I really thank you, sir, for coming ahead and doing this voluntarily, because I understand it's not very easy to do so. So I'm just taking this example, which is why. Okay. So that, okay, so then you don't introduce and you don't share your dynamics with the parties ever. Okay, you will never say that I appreciate party A for doing this, I appreciate party B for doing this. Even if you are doing their appreciation equally, it is still not required, because you are a neutral party who has nothing to do with the parties. You should not be knowing the parties from before. If you know, you have to disclose that prior to mediation. Okay, and both the parties have to be comfortable with it. So you cannot be knowing that. Now, for example, let's say in this particular case, if I was a woman and I was a mediator, and I would constantly say, no, Miss Sheena is a very good housemaker. Okay, she has been a very brilliant person. She's been a lady who is balancing her home and her outside. Immediately, the husband might feel, now since the mediator is a woman, she's going to support my wife. In practice, ideally, even if the mediator is biased towards someone, it is never going to help anybody's case, because it is the clients who decide what you're going to settle. Mediator never decides. Okay. In practice, it's not going to lead the decision to anywhere, but it is a psychology that gets created. And eventually what happens, you don't trust the mediation process because you think somebody is biased. Even if the mediator is biased, it doesn't really change the matter, because clients decide, mediators don't. Okay. Asha, secondly, you need to do, after you introduce yourself, you introduce what the process of mediation is, because you understand the people who are coming in probably are not very aware of mediation, because it is not compulsory in our countries to, have these pre-mediation counseling sessions where you sit with the client and explain what mediation is. So in short, you have to explain them in say 2 to 3 lines. You have to sort of explain it to them what mediation is. Then you talk about the stages of mediation. Okay, so then you say that after I complete my opening statement, we will go to, so you already asked this in your welcome that who wants to go first, or you can ask at that point as well. So please let me know who wants to go first, and that particular party can go first, and then their lawyer can follow, and then the opposite party can go first, and then their lawyer will follow. Then we will have a discussion jointly, and then we can break into private sessions. Okay, so when you said this thing that you can take a break anytime you feel like, that is not something that we encourage. Okay, so if you're feeling emotional, if you're feeling like you need to vent out, you cannot break and go out, because in mediation, unlike courtrooms, we address emotion. So if somebody is angry, we encourage them to speak. Of course, in a not in an aggressive manner that the person can't come in and abuse and can't hit, because those instances have also happened where people are fighting. They just stood up and they just wanted to hit. Okay, so that is terrible. You can't You can't have a parliament going on inside the mediation room. That's not working. But you have to let the emotions out. So if somebody is crying, you need to let them cry. But obviously, as a mediator, you understand that there are some people who are crybabies, who are going to cry. তারা কাঁদতেই আসে, তারা কাঁদতেই থাকবে, তাদের কোনো ফিউচার নিয়ে কথা বলার কোনো ইচ্ছে নেই, তারা শুধু কমপ্লেন করতে আসে। You will find parties like this as well. In such scenarios, you put a full stop, and what you do is you tell them, why don't we have a private session? So in the private session, you take them, you separate, so that the other party or the disputing party does not get irritated, that it's too much about this person and his crying or her crying. So you separate them in a private. So what you can suggest is, if you feel and if you want to, we can break for a private session whenever you feel like, okay? But we will try to keep it more with everybody sitting together, okay? That is something. I really appreciate how you said that, nobody would interfere and, speak in between and all of that. So that is good. It is very important to set the ground rules. I would say that nobody can use their cell phone. Nobody should even have their cell phone. I would explain the confidentiality part a bit more. Okay, because the most important thing about mediation is it is confidential. Okay, and how you said that we will destroy everything, that is a brilliant thing to do. I would always mention that. Okay, so anything which is remaining will be destroyed, and it's not going to go anywhere. So that is important. A couple of other things that I think needs to be mentioned more is, I am neutral and I am impartial as a mediator. You decide what you want to decide, and you can go ahead. At any point, if you are not, though it is not encouraged by a lot of people in India or Bangladesh, I would not, sort of ask you to say this, that you can walk out of the mediation room if you're uncomfortable, if you're not willing to settle. Because if you say this here, then people will walk out at the first instance. So don't do that. But if you are doing an international sort of a mediation, or some place where people are more aware about the process, you can also mention something like that. Okay, so this is sort of my feedback. Thank you so much for coming up ahead. And
Ms. Priyanka, one thing I was very skeptical that whether to mention the fact that I know in the welcome address, whether to mention it or just, I skipped it. I deliberately did not mention anything about it, but I was puzzled that whether to mention it or not.
Mention exactly what, sir? The
fact that you have shared with us. I know the fact, what is going on between the parties, what is the fact, what is the issue.
No. You will never do that. Okay, so when you enter a mediation room, you are completely neutral. Even if you have a pre-client counseling, you come inside a mediation room as a mediator knowing nothing. So you tell the parties to tell their story through their opening statement. And you have to act and behave as if that is the first time you're listening to their story. In a lot of cases, it will be true, because you will not have the privilege to have a pre-counseling session with either of the clients. Okay, so just go like you know nothing about the case sheet, right? This is how your approach should be. I hope I answered your question.
Yeah,
yes,
thank
it
you.
was a great attempt. Thank you so much for doing this. Anyone else who would want to read out their opening statement? Please don't take this as a criticism or as like it is just, if you come up with your opening statements, we can discuss more and learn more about it.
Hello.
Yes, sir, we can hear you.
Yes. Am I audible?
Yes, sir, you're absolutely audible. Please.
I'm Tanvir Ahmed, Joint District and Session Judge, Shirazganj District Judge Court. My opening statement as follows. Hello, Ms. Sina and Mr. Akhtar. Assalamu alaikum. How are you all? I'm fine. I'm a mediator. Have been here before you to give a guideline to solve the problem of both of you. I have no connection any of you before this time and have no interest in the disputes. What problems you will share with me will remain confidential and will never be disclosed after the session.
Sorry, sir, your voice broke in between. Can you please repeat the last sentence? Thank you. No worries.
I'm beginning again. I have no connection any of you before this time and who have no connection and have no interest in these disputes. What problem you will share with this will remain confidential and will never be disclosed after this session. If finally you are not able to agree to resolve this problem through mediation. Mediation is a process which give you a just way to solve the problem of both of you. It's not mandatory for you, it is optional for both of you. Both of you can share your problem with me. I will just show you the way in which you can go for solve your problem. I will not impose any decision on you. Just I will just you will find you pick up the way you can get solution. Each of you can share your problem personally or by your advocate or by your representative. If both of you solve your problem by your own optional way, you have to conclude it by a written agreement between both of you, and this agreement will be part of a degree of the suit. If both of you solve this problem by mediation, it will take short time. It will take short time to dispose the case, and that will take comparatively less money labor than that of case procedure. Rather than this degree on this basis of mediation is not available, and the solution will be permanent, and the solution will be permanent, and never you are come to the court for this problem. Would you like to agree to solve this problem this way? Please, each of you come forward and share your problem with me openly. Thank you.
That is great. Thank you so much, sir. I definitely appreciate it. It's a very good try. So if we discuss your opening statement, okay, so a couple of things that I would want to point out. So when you said in the beginning as sort of a disclaimer that I don't know you from before, any of you, okay, so it's a good thing to say that, okay, sometimes voluntarily saying, I mean, it's not important to say that, but since you're saying it and I say it's a good thing to, you know, say this ahead that I am not aware, I did not know any of you from before. Okay, so it's a good thing to do that. One thing that I want to say, when you said that it is not compulsory for both of you to be here and solve this, instead of saying this, because when you say it's not compulsory, the weight of mediation gets very light, you know, so people think, oh, this is just like a process, we'll just, you know, it's not compulsory, so that importance goes down. So instead of saying that, if you say, I really appreciate that both of you have voluntarily agreed to take this process and be a part of it, what happens then is you are appreciating the parties. Instead of taking down the weight from mediation, you're actually appreciating, and you're also telling that the process is voluntary. So it's not compulsory, but you are sort of rephrasing it. Okay, so that I definitely appreciate. And so when you said things like, I want both of you to come here and share your problems, and I'm not going to make a decision, but I'm going to help you find a way to create solutions. Okay, so that is true as to what we do, but if you are talking about that in that manner, it sort of shows that you are the one who is in control of what is happening. Okay, you are in control of the process as a mediator, of course, but you have to show and give more power to the clients. Okay, so you can reframe what you are saying instead of saying something like, so I really appreciate that you both came in voluntarily and took up this process, and I am just here to help you, and help you into settling the dispute that you have. You are the ones who are going to decide what is going to happen. I'm just going to be here and be there for both of you whenever you need me and whenever I think fit. I will not judge, and we are not here to judge anybody. Another point that I think we all missed was talking more about the future. Okay, so it will be more interesting if we say, so from here onwards, we will start thinking about the future rather than the problems of, we'll solve the problems of the past and think more about the future. Okay. So putting something like that in between will also be a good idea, right? But otherwise, it was a definitely good try and great. I mean, all of you are doing really, like, we had two great examples to discuss. Anyone else who would want to go ahead?
Yes, ma'am, I have a question.
Yes, please.
You said that we are, as a mediator, we have to act like that we don't know anything about the parties and about their respective claims. I'm a judge from Bangladesh, and in this training program, approximately half of the trainees are judges. And we cannot act as a mediator as our independent profession. We have to do it within the legal bindingness in courtroom or something like that. We have legal bindings when I'm going to explain it. Please give some time. When both the parties submit their respective written statement, pleadings, something that means one party has submitted their plaint, and in respect of that, another party has submitted their written statement, and after that we can ask them to have one mediation, not before that. That means as both the parties have already has submitted their submission in writings to us, then how it will be possible that we don't know nothing about their respective cases? Is it possible?
Okay, sir. So even as a sitting judge, so when you have the written statements already submitted, do you ever enter a court and say, okay, client number A, I know you and I know your background and your story and your claims. Client B, I know your story and your claims. It's okay. I know what is going to happen. Do you ever do that? No, you wait for them to present their cases. Even as a sitting judge, even if you know what is there in the statement and you have submissions, you still hear them out, and you actually act as a neutral person who is hearing the story for the first time. Even as a judge, I think you don't sit here already thinking. I mean, I don't think it will be ideal if I would already in my head process what I want to say before even hearing the parties out. You getting my
Okay.
point? What I'm saying? Even as a judge, I don't think you make the judgments before entering the court, right? Even if you know the story, you hear the parties plea, right, from both the
Okay.
sides, and then you decide. So even as a judge, I think you're sitting there acting like you don't know anything and you're hearing that for the first time. So it's
Okay.
not very
And that means I have to act like that I know nothing about you.
you don't
Something like
have,
that.
no, it's not like you know nothing. You just have to not mention that you know something.
May I say something, Priyanka?
Okay.
Yes, definitely.
It is not really necessary to rub it in that we don't know them or we don't care who they are. I think what Priyanka is trying to say is that you need not be so vocal about it. The intention should be just to communicate that you are unbiased and you do not have any opinion about this, the outcome of the matter, and that's about it. So whichever way you want to rephrase it, you don't really have to tell them, I don't know you, or I know you, or I'm happy with you, or I'm unhappy, or, I've read your work or not. I think that's the gist
Okay.
what Priyanka is trying to say. Thank you.
Yeah, thanks, Dee. So basically, I'll tell you what is the reason behind this entire thing. Okay. So what we are trying to do in mediation is we are trying to create a space which is confidential, okay, which is not public, unlike court system. And it is also a safe place. We say that you can come in and you can speak about anything without being judged. Nobody is going to judge well whatever you're doing is right or wrong. Okay, who is going right, who is going wrong, none of that is happening. So if you're trying to create a space which is free of judgment, you cannot come in and sort of like put in things like that, okay, I know you are good, I know you are good. The moment you do that, it sort of creates that space which, like, you have already learned about them and you have sort of created an image in your head. Right. So, for example, when
Okay.
the first example of opening statement we had, when he said, I have read your articles, automatically the idea is you have read that person's articles and you think that the person is intelligent because he has written brilliant articles. So maybe whatever he speaks is not going to be absolutely, ridiculous. This is something which start creating in our heads. Okay, so just to create that, as Ashadi pointed very well, is just to keep the process neutral and impartial. It is very important that we do not discuss or dwell into it too much. It's not that you are not well read. Of course, you have to be very well prepared when you are entering a mediation room as a mediator. You need to know what is happening and what's the background and everything. You just don't need to, say it out loud. Okay. You just-
Priyanka, may I add something?
Yes, sir, please.
Yes. So far as the contents of the case is concerned, in fact, the mediator is in a far better position than a judge. Because in a court, the judge will obviously be asking questions, if he asks questions, which will relate to the materials that he has already read. Whereas in mediation, he doesn't have to know anything about the case. He will only hear from the parties when the parties are talking to each other. And therefore, he doesn't have to mention even that he knows anything about the case or he doesn't know anything about the case. He doesn't have to mention the case at all, because it is not the purpose of his presence to decide on the case, to decide on the issues, to ask questions about the materials in the case. Nothing to do with him at all. So mediator is in a best position. He doesn't have to say anything about the case. He simply has to make sure that the parties give or bring forward their views about the case, their views about the issues. Each will have their different attitudes about the issues, and that is, they will decide it. They will iron it out.
Absolutely. Absolutely. Thank you so much. So just summing it up, mediator basically has an eagle's eye. Okay, you are flying from above and you are seeing what is happening from the top, and you're seeing from a very neutral position. Okay, that is exactly how the mediator should be dwelling. Just one more point that I want to mention in the previous opening statements, or I'm sorry, I missed out. There's too much to process. So when you said that if the party is not comfortable, they can let their representative speak. That is something we do not do in mediation. The parties have to speak. So there is no representative who is going to speak for the clients. Okay, the clients are the one who are going to speak for themselves, no matter what. Sometimes we do get clients who are not confident enough, and they are, they are probably for cultural reasons or whatever reasons they are not. Probably they have a bad throat or something like that. You can have certain issues as well that the client doesn't want to talk because he or she is not well. In such a case, you can request that since I'm not well, I have said enough, and my lawyer will speak on my behalf. But it's not something that we encourage. We want the clients to be the ones speaking and not their lawyers or their representatives at any point. So as I mentioned earlier, even as a mediating lawyer, you have to control your urge to speak. And I understand, honestly speaking, judging and mediating is like the exact poles apart. So if you, whatever you need to do as a judge are exactly what you need not to do as a mediator. So being a judge who is a mediator, I think, is the most tough job to do, and hats off if any of you are doing it. I mean, it's incredible, because exactly what all you need to do as a judge is exactly what all you do not need to do as a mediator. It's a very tricky space, and I'm glad that all of you are so positive about this process and are here to take this training, if I have to say so. Okay, anybody else has anything to share or point out or discuss? It's good to be vocal.
Madam Priyanka, before going to next, I mention one thing.
Yes,
In
sir.
our country, Supreme Court issued two circular. One circular dated 5/8/2021. There is some guideline for the judges as mediator. So it is very effective if that person, that is a learned assistant judge who questions to you, if he or she read that circular, then effectively solve what you say. And also what opening session, what I say may be appropriate if he or she read that circular. One thing, Priyanka, somehow Bengali, 2 নম্বর অনুচ্ছেদে বর্ণিত বিষয়াবলী পক্ষগণকে ব্যাখ্যা করার পর, অর্থাৎ earlier our circular say first you explain যে তুমি মেডিয়েশনে আসবে না, মেডিয়েশনে উপকারিতা কি। Yes, I am judge, that's court. Okay, but what circular say, প্রথম ব্যাখ্যা করে বলবে মেডিয়েশনের উপকারিতাটা কি, মেডিয়েশন জিনিসটা কি। যেমন ম্যাডাম প্রিয়াঙ্কা আপনি যেটা বললেন সেটা হচ্ছে যে এটা অতি গোপনীয়, এই কথাগুলো সার্কুলার মধ্যে রয়েছে। এই কথাগুলো বলার পরে উনি কি বলছেন, উনি বলবেন পক্ষগণ সম্মত হলে আদালত নিজে, দ্যাট ইজ দ্যাট জাজ, মধ্যস্থকারী হিসাবে মধ্যস্থতার আলোচনা শুরু করবেন, অথবা মধ্যস্থতার জন্য সংক্ষিপ্ত বিরতিতে পক্ষগণের সুবিধা মতো একটি তারিখ নির্ধারণ করবেন। Very important for judge of our country, that is in Bangladesh. So if he or she, that is all judges, if read that circular, it is very easy for them for opening session what he or she say. I think my understanding, that is 5 তারিখের এই সার্কুলারটা যদি সুন্দরভাবে আমরা পড়ি, একজন জাজ হিসাবে উপকৃত হবে যে ওপেনিং সেশনে ওপেনিং স্টেটমেন্টটা কি হতে পারে। থ্যাঙ্কস।
Thank you so much, sir, for adding that. Mane, I think it's an incredible thing. If you have a guideline like that coming from the Supreme Court, I think that's perfect. Okay, but that's great to know. So I wasn't aware of that circular. Thank you so much, sir, for sharing that. So I think we are good to go on opening statement. But before we move ahead, I would request all of you to look at this particular marking that I have assigned for everybody. Just a moment, yes. So why don't all of you, if you can see my screen, I'll just share the screen. So I'm sure all of you have written your mediation statements. So why don't you, pick up from the pointers that I have given and mark yourself. You just have to assess yourself. Nobody's going to assess. These marks are not important. It's just for, your own reference. And so if you think that your mediation statement is can be finished within 8 to 10 minutes, honestly, if I have to say, when we were doing the first mediation training together, I was taking the mediation training. So when we were supposed to write opening statements, we ended up writing like paragraphs. So our opening statement went from 15 to 20 minutes and all that. So it was very difficult. So I'm really glad that the 2 opening statements we heard were really short. Okay. So the ideal time to have an opening statement is between 6 to 7 minutes. But in practice, it comes down to 8 to 10 minutes. Okay. So if your opening statement is within that, please score yourself 10. These are the marks that I have sort of assigned based on the importance. Then if you think you have covered the mediator's bio, what I mean by that is you have introduced yourself saying I'm so and so, and I have this much of experience, and I have taken these many mediations, and I have observed these many mediations beforehand, and this is my, say, 10th mediation or 20th mediation or however it is. Okay. So if you have covered that sort of a structure, if you can say that I'm an expert, I am doing my PhD, or I'm also doing my doctorate in mediation, and I'm studying about this and all that. If you want to say, a brief, if you have covered that, please mark yourself 5. And okay, then if you have set the rules of the room, like no mobiles or timelines or no smoking or no interfering in between, if you have set things like that and you have set out a couple of rules, you can mark yourself 15 for that. We will just, have a score so that all of you know if you have covered the important points or not. That's about it. It's just a fun activity, nothing major. So after that, if you have sort of mentioned and explained the characteristics of mediation, and there are a lot of characteristics that needs to be explained, but if you have explained these very basic, please mark yourself 5 based on these things. Like if you have mentioned the word neutral or neutrality and impartial or impartiality and confidentiality, and it is non-binding or voluntary, and the parties decide and not the mediator, if you have mentioned these, because these are the most important aspects that cannot be skipped, please mark yourself 5 on each of these. And then if you have explained the steps of mediation, as mentioned, so while explaining, if you have talked about opening statement, if you have talked about what is a joint session, if you have talked about private caucus, and if you've talked about settlement, please mark yourself 5 for each. If you have not mentioned, please don't mark yourself. I mean, nobody is going to tally the marks, so it's okay. It's just for your own assessment that you will, get an idea. Then you come down to the role of a mediator. If you have explained a couple of things that a mediator does, for example, mediator drives the process. So these are the pointers which are important and it shouldn't be skipped in an opening statement. Mediator drives the process. It helps keep focus on future and will not provide any advice, will keep everything confidential. Okay, so mark yourself 5 of 5 on all of those. And mark yourself another 5 marks. The table was actually big, so I think the presentation sort of couldn't cover it. Mark yourself another 5 marks if you have talked about the advantages of mediation. Five more marks if you have talked about what is the advantage of mediation. And just a bonus 5 for doing this exercise. Okay, just a bonus 5 to everybody just for doing this exercise. Okay, great. So now we have a complete score of 100. Do you think any of you have scored 100 on 100?
Not really.
It's a difficult task, trust me. I mean, the best part about both the opening statements we heard was it went so smooth. I mean, it was so short. We ended up writing a paragraph or two. I remember my first opening statement, I wrote like 2 pages back and forth. It was like 20 to 25 minutes explaining everything. So yeah, I definitely think all of you are doing so much better than whatever we did. Okay, I am really sure that none of you have scored 0 was not an option, well, 5 as well. So I mean, good work. If you haven't, I think you have at least pointed out what the pointers were. And whenever you're drafting an opening statement, please ensure that you have all these points in your opening statement. And as Goswami sir mentioned earlier, you also have this recommendation from the Supreme Court that you can, look into and take. Draft your opening statement very carefully. And if you have a perfect opening statement, you can keep on using it on all the mediations that you go, because you never talk about the client in there. Okay. Okay, great work, everyone. Thank you. Okay, somebody's sharing their score as well. 55, great. That's a great score. A big round of applause. Actually, a big round of applause for anybody above 50. I mean, it's great job done. Okay, so moving on. I really wish we could have done this non-virtually. It would have been much more fun because we could have done real mediations and, discuss more about it. But as our lives, you're all becoming very digital. So, okay. So moving on to the next presentation that I have is what is the role of mediator? Just give me a second. I'll just share my screen. So these were basically the pointers of what needs to be an opening statement. Opening statement is actually very, very important, which is why I am like so obsessed with it. And I wanted everybody to do this exercise because it is very important to have a perfect opening statement. I'm so sorry. So that was very important. Well, now moving on ahead. So the next topic that I'm going to discuss is the role of a mediator. At any point you think you want to share your opinion or talk about it, please unmute yourself and let us know. It would be good to hear from everyone else as well. Now, we all know what a mediation is. Mediation is often described as both an art and a science. Okay. Now, a science because the practice is governed by a clear framework. So we actually have a structure to mediation, which is sort of a concrete technical one. Like there's welcome, there's opening statement, there's joint session, there are private sessions, there's closure, there's settlement agreement. It's very structured. But when it comes to practice, it is very different. So my mediation will be very different from what, say, Mr. Goswami's mediation, or what Ashadi is practicing as a mediation, or what Justice Ali is practicing as a mediation, right? So all of this is going to be very different, okay? An art because skilled mediators draw on a variety of less tangible assets like intuition, self-awareness, emotional intelligence, and gift for cultivating trust amongst tension and hostility, okay? So, which is why mediation is a very tricky thing. And the more you practice, the more you become better at it. It's basically a skill set. Now, who is a mediator? A mediator is a neutral third party who assists both the parties to arrive at a settlement. A mediator helps resolve a dispute and basically acts as an intermediary or a go-to for both the person. Now, the mediator first initiates the meeting. I think somebody has access to my screen. Just a moment, okay? I'll just stop and I'll. Sorry for this disturbance. Yeah, this looks better. So the mediator is always the first to initiate a meeting and initiate discussion. So for example, if you are a mediator and you are sitting in a room where nobody is talking, okay? So what do? You can't just chit chat and, do stuff like that. So if you are in a fix like that, generally as a mediator, I would suggest to have some chocolates and some toffees in the room, okay? It helps down sometimes. When you mentioned earlier that in one of the examples of opening statement, we had this thing that, I have got chocolate for both your kids and all that. No, that is not encouraged because you don't want to create a personal link. Understand that mediator is going to be a person that both the parties trust and rely on, but somebody you don't have any personal connection with, okay? So you cannot personally connect with the mediator. That is how it has to be. It's like, I don't know if I can give you a real life example of who a mediator could be in your real life, but you can't necessarily have a personal touch to it, okay? Of course, when you're discussing emotions, you have to be very empathetic. And empathy is one of the main and the most important things that a mediator must have. A mediator must understand. So, for example, I am having this dispute. The example that we used. So, in there, let's say the husband and the wife is crying, and I'm just sitting there as a mediator, and I'm like sitting like this. Okay, I'm just waiting for her to stop. So, if that is going to be my demeanor, that is terrible. The wife will immediately snap after a point and she'll be like, oh my God, she's not interested. She thinks I'm a joke. You cannot do that. Okay. So, but does that mean that if she's crying, I'll also start crying? No, it doesn't mean that. What I need to do is I need to make her calm down. Okay. So I need to say, I'm really, I understand. Please take your seat and let's talk about it more. Okay. And for example, if she's crying a lot and she's unable to speak, so now what do? Do you stand up and you pat her back and and you're like, no, please don't cry, it's okay, it happens with everybody? Can you do something like that? No, you cannot. If you are standing and consoling one party, the other party will automatically feel that you are inclined towards one. in such a case, what do? Which is why I said you can have those chocolates and toffees handy. You let the person cry. You probably pass on a tissue saying maybe you will feel better, and you pass on a tissue, or you pass on a chocolate, or you give her a glass of water. Okay, you do something like that to stop and control the emotion, but not, sort of like cut it out, saying like, let's take a break. She's crying. No, no.
Please have
No.
something for diabetics also.
Sorry. We do have sugar free. I'm not sure we do, but we do have diabetic sweets in Kolkata. So maybe something like that. So yeah, I'll keep this in mind. Thank you. So, but something like that, okay, to interrupt and to sort of lead it in a positive way. But don't do things like that. And trust me, as a human being, it is very, very difficult. If you see somebody who is very angry, we once ended up having this. So we were trying to do this mediation between Amazon and a customer who had bought shoes. Okay. And this we were doing under a project in National Law School, Bangalore. So the person who had bought these shoes from Amazon. So understand, on one end of the table, these are managers sitting, two managers from Amazon India. They are like all suited, booted, and everything. They're well-dressed gentlemen who are sitting with impeccable English. And on the other end comes this person who is wearing a dhoti, and I'm sure he never sat in a wheelchair, probably. I mean, not a wheelchair, I'm sorry. On a chair with wheels, those rotating ones, the comfy ones. So he was sitting on that, and he was constantly, like going right and left, and he was dancing on in whatever manner, because I understood he has never sat in such a chair. His claim was very simple. Whatever, I'm not going to get into the details, but that is how uneven or absurd the mediation room was. Now, as a mediator, that day I realized I'm never going to keep chairs with wheels in mediation rooms. So I'm going to keep only static chairs. Because if you have chairs like that, there could be a tendency that people move it around because they are getting irritated, or they are losing their concentration. And it's okay sometimes to feel a bit lost or something like that, but it's not okay to show it in front of the other person. So just to stop that, I decided I'm not going to keep chairs like that. So henceforth I have started keeping static chairs, which are like fixed and they don't move around. A lot of times you will see that mediators are sitting and doing this. So the moment you do this, it's gone. Immediately one of the party notices, they'll realize you're not listening. And that's not something that you are going to like. So as I mentioned earlier, active listening is a very, very important part. Anyways, I think I drifted a lot from what we were discussing. So the mediator assists and guides the parties to their resolution. A mediator also offers creative approaches and innovative solutions while maintaining an unbiased perspective. Now, what I mean by unbiased perspective is, for example, when we discussed, I was telling this example of a brother and a sister, if you remember correctly, in the morning today. The brother had come back from US, and the sister is living in Bombay. Now, as a mediator, if I suddenly, end up saying something like, when the sister says, okay, you are in US, why are you doing this? Why do you need money and all that? So if I say something like this, yes, my brother is also in US, he's earning well. Now, this has nothing to do with the clients, but the moment I say something like this, it's going to be like, oh my God, this person is judging me, and it's unfair towards me. So the particular mediator is partial or something like that. Okay. Or for example, if I, for creative approach and for providing creative solutions, so when they came up with that Delhi house that the sister owns, she can rent to her brother, what the mediator did was the mediator merely pushed them towards that, saying, okay, so what do you think could be done? Okay, so what is a possible solution? Do you think there is something we can work out here? You ask questions like this. You never say, oh, so you have a house in Delhi, why don't you rent it out to your brother? If I say that, again, I am sort of showing a partiality towards the brother, and I'm not being neutral, because I am trying to force them into a settlement. Somewhere my idea is, when do I finish this mediation and get them settled? If as a mediator, I am too much into getting the matter settled, even then I'm not being neutral. Okay. So trust me, it's very, very tricky, and the perfection doesn't come in a day. and everybody has different styles. People's mediation, sometimes, my mediation might not be comfortable or compatible to you, but it could be compatible to say ABC. And maybe my mediation style is good for corporate, not for family. So when you are actually going to start practicing mediation, you'll eventually realize which topics or which cases would suit you better as a mediator. Are you comfortable with handling, or you are expert in handling a lot of emotions? Then family is definitely a good to go. A lot of mediators do not like to handle emotions, or they're not comfortable in they're not experts in handling emotions, because handling emotions is really, really tricky. So they end up doing commercial mediations and sort of those. So you have to find out your own niche zone as well. So if you are a mediator, doesn't mean you can mediate everything and anything. Okay, it doesn't work like that. You have to find out your own zone as well and you start mediating. Now, what are the mediator's duties? The mediator's duty is to conduct a mediation in fair and unbiased manner, to decline or withdraw from a mediation if the mediator cannot remain impartial. So, for example, I have a mediation going on between A and B, and I come back to the car crash story again. And then suddenly I end up realizing that A is basically my brother's close friend. Maybe he refers or mentions something or something like that. So the moment I never knew about it before the mediation, but during discussion, I realized. So the moment I realized, as a mediator, I have to point that out. I have to say, okay, I'm so sorry, but through this discussion, I just realized that my brother is a good friend of you, and I'm not sure if I would be the right person. If both of you are comfortable with me continuing with the mediation, I'm more than happy to take it ahead, and I can assure that I will be impartial. But if either of you are not comfortable, I am very happy to walk out, and you can please look for another mediator. So that is something that you have to do as a mediator, okay? To decline or withdraw the moment you know that there is some sort of an impartiality. Or for example, it also happens that maybe, for example, I, as a woman, I come across a mediation table where there's some physical violence against a woman, and let's say in my personal life I have faced a lot of physical violence and abuse and all that. So the moment I start talking about that and I try to resolve that, it's all going to come back, and somewhere or the other I'm going to be partial towards the woman. So I can just say, I don't need to always cite my reason. I can say, I don't think I would be able to be impartial to the cause, so I think I'll withdraw myself from this mediation and somebody else can take it. So you have to be very honest, okay? As a mediator, the most important thing is you have to be very, very honest, and you have to just know that this is not your place or thing, and you have to back off. It has nothing to do, I mean, I think it will just prove that you're a better human being if you actually withdraw rather than staying there and being partial somewhat. Okay, to make reasonable inquiries to determine any potential conflicts, to maintain the confidentiality of mediation, and to conduct the mediation in accordance with the set procedures and laws of land in place. So we do have a couple of guidelines in various countries. We do have a mediator's rule book, which is recently here in India in the last 1.5 years. It's not like a compulsory Bible sort of a thing, but it's still there as a reference. So you have to follow the laws of the land. Like if for example, in India, we generally do not take cases in ADR which are generally against the public law. So for example, if there's a terrorist activity and somebody comes in for mediation just because the parties are wanting it, I cannot take that up. It has to be within the realm of the law of the place. Okay, so that is important. Now, what is the role of a mediator? The main role of a mediator is to facilitate communication. If I have to say, the role of a mediator is multifaceted and it's very tricky. Sometimes you have to be silent as a mediator. Sometimes you have to speak a lot, ask the right questions, and direct them in the right way. Sometimes you have to break arguments and discussions. Sometimes you have to make them argue or discuss because they both want to, and they have this boiling emotion inside themselves, and only when they vent it out will they be able to actually see past the problem and see past those emotions. So you sort of like pinch them to actually end up arguing and fighting, and then once they are cool, then you tell them, now let's find a solution because the problem is already there. So it's varied, it's really varied. But yeah, in generalization, if I have to say, it's to facilitate communication. It's setting up meeting between both the parties to decide when they are going to, the scheduling the thing and the place and the venue and everything. Review the mediation proceedings in the first meeting, and he also invites the parties for the brief description. And it basically it means is after the opening statement of the mediator invites both the parties for their opening statements. Okay, and then he discusses about the issue in hand and tries to come up with a solution which is viable to both the parties. So always remember, your job as a mediator doesn't even end with the settlement agreement. You have to check the viability and the practicality of the settlement. If the settlement agreement has points which are absolutely impractical and cannot be happening, then there is no point. It basically means it's all going to come down to the same cycle. So you have to check whether the solution that the parties have agreed to is practical or not. Now, what are the attributes of a mediator? A mediator has to be attentive, active, and a patient listener. The mediation process starts with the parties narrating their case, their perspectives, and venting out their emotions. This is a very important stage in the process of the mediator to identify the real underlying issues between the parties. The mediator has to be an active listener and not only listen to the spoken words, but also understand the body language. Absolutely so. As a mediator, if you see that somebody is speaking and constantly, like tapping their fingers like this, with all possibility, the person is probably lying, or the person is blinking too much while saying, probably the person is lying. So as a mediator, if you see that something like that is happening, you will probably want to, take control over it. You can't say, I think you're lying or something like that. No, you don't do that. But you can take them into a private caucus and say, why don't you share what really happened, and why don't you talk about it a bit more? So you have to create your own techniques. There is no said rule or book or method to do it. Actually, it's like cooking. You have the same ingredients and you have the same things, but everybody's dish is different. Though it's the same dish, everybody makes dal, but everybody's dal tastes different. It's something like this. Okay. Then empathy, of course, it is most important. And by empathy, I don't mean sympathy. Okay, sympathy is sort of a negative thing. It's more like charity of emotions. If you're talking about sympathy, oh, I'm so sorry this happened to you, I feel so bad. No, that is sympathy, and we don't want a mediator to be sympathetic. What we want is empathy, is to understand, like, you be in that person's shoe and understand why is the person reacting so much, or what is the person going through. Only when you understand their emotions is when you can understand what is happening below those emotions, okay, under the blanket of those emotions. So stepping into the shoes of the parties to understand the issues from their perspectives. This does not mean that the mediator should agree with either of the parties, but it is also important to see and understand the situation from the respective sides. Sensitivity. A mediator has to be very, very, very sensitive, okay. You can't be like this prude and egoistic person sitting in between, like not caring about whatever is happening. You cannot be that. You have to be a very humble, kind, honest kind of a person. It's like the ideal person to be. So you have to be very sensitive as to what people are saying and how they're feeling. You can't just, and I have seen this, okay, I have seen this very unfortunately in a mediation that was happening. I think it was a child custody scenario, and the parents were bickering over it, and the mediator got really pissed off, I think, at some point. But no matter what, if you think you're really angry, okay, like you cannot take this anymore, then you break the mediation. You say, okay, I think we have discussed enough. Why don't we take this discussion on another day and we can schedule it, and you reschedule it, okay? Or take it to another day or another time, or take a break, grab a cup of coffee, or do whatever makes you happy, okay? But don't ever come across to the party. So that mediator just went across and said, what the hell is wrong with you? And the person used even worse language. I can't use that here, but the person just went and like, what the hell is wrong with you? Why don't you guys settle? You really think you're going to be able to settle with so much of issues on you have so much of baggage? And he just kept on venting. It was more like a venting for mediator. And I understand he was pissed because the same discussion over the same issue was going on for like 5 to 6 hours. And sometimes, even if you are a very good mediator, it is very difficult, to get the parties to speak because everybody is not of the same mindset. But as I said, no matter what, in such a case, take a break, reschedule the mediation if you think it's not working out, or do whatever, but never be insensitive towards the parties. Never say anything wrong or bad to them. Okay. um, because if you do that as a mediator, what happens is the parties lose faith over the process of mediation, and that is not good. Okay, because we are trying to have people to mediate rather than not do it. Okay, neutrality. The mediator has to be non-judgmental and objective. In some cases, the mediator may come across where settlement terms may seem unfair to one of the parties. In such situation, if the mediator tries to step in to bring about a balance or change of terms, then the mediator is not neutral. Okay, and I say this with all fairness. Sometimes what we understand as justice is not actually justice. Okay, so as a mediator, if you see that the settlement agreements is partial towards one of the parties, but both the parties are happy with it, you just let it be. Don't try to step in and be like, no, I think this should go, or whatever. Your opinion is not solicited, it's not asked for. Even if people ask saying that, Mr. Mediator, can you please say if this is fair, if this is good, you will not be the person commenting on the fairness or judging anything there. Okay, so just be very, very vigilant about it. Being neutral is very, very tough, but that is one of the main attributes of a mediator. And to create rapport and trust. As I said, in the very welcome, you can welcome the person and you can create your rapport and trust. Your handshake will make a lot of a difference. If you're having a handshake which is like wobbly, like handshaking like this, the person knows this person has no authority. Or if it's too hard, the other person might get intimidated. For example, if somebody was coming in for let's say namaste or assalamu alaikum or however you greet, and the other person goes ahead, jumps and hugs the person might be intimidated. Oh my god, this person is a bit too physical or something, whatever. Okay, so be very how do I say, be very intelligent in how you greet people, if I have to say. Be very vigilant, understand the frequency of the person who is walking in, and make sure that it's okay. And also another thing, the language of mediation also is very important. So if you have two parties, as I said, the example where Amazon had this customer claim, so there even though the Amazon people were inclined towards speaking in English because that is what comes easier to us while at work, but then because the other party could not understand English well, so we turned down to Hindi. Okay, so even if it was a bit difficult, but we all had to converse in a language which was applicable. And in such a case, it's not very advisable to have a translator. Honestly, at local levels, you hardly will have translators doing that because that's a lot of money. But yeah, I mean, it's better not to. So creating the rapport and trust is also a very important attribute of a mediator. And what are the others? Is to complete genuine and unconditional faith in the process of mediation and its efficiency. So as a mediator, you have to believe in the process of mediation. As a mediator, if you are somebody who says that, okay, I believe in mediation and I am practice and I'm all for mediation, but in reality, you're like, oh, mediation, it doesn't work. People end up coming to arbitration, litigation. If you are somebody who thinks like that, it is going to be difficult for you to be a mediator. Honestly, you have to believe in the process. It is only when you believe you will make the parties believe. Okay. Ability and commitment to strive for excellence in the art of mediation, higher standards of honesty and integrity in conduct and behavior, a calm, pleasant, and cheerful disposition. Your personality has to be a good personality. You have to be a very patient, calm, and a nice person. If I have to say, you have to be a nice person, but not not be somebody who can be walked over all over. I mean, it shouldn't be anybody can come and walk all over you. No, you have to have a very nice but a very stern personality. Okay, you have to be like, okay, this is my rule, this is how it goes, but that doesn't mean I'm rude or anything. So that, okay. And you have to have patience, persistence, and perseverance. Good communication skills, of course, that is all you need for mediation. Open-mindedness and flexibility. You might come across ideas and suggestions and settlements which might question something with your culture or your understanding of the country or the people or your neighborhood or society. But if the parties are happy with it, if it is not against the laws of the land, then please let them go ahead and be happy with it. Okay, so don't try to be very close minded and sort of like not flexible enough, and be creative. Okay, keep asking the right questions, keep pushing them, keep telling them why do you think, what do you think, what could be done. So ask all sort of questions and make them push. Now, what are the attributes of a mediator? You should have big ears for listening, clear eyes for seeing, small mouth so that you focus on talking less and listening more. You have to have a big heart full of empathy. You have to have a sturdy backbone for support. You have to be strong, otherwise, how will you support your clients? And ego has to be contained. Your ego cannot be on the table at any point, because as a mediator, a lot of times you will feel you actually know way more than probably what the parties know, way more than what their lawyers know. And if you are a judge who's sitting as a mediator, of course, you will be knowing way more than anybody else in the room. Okay, but that should never come across you as a mediator. Okay, your ego has to be packed and thrown out of the window. Your ego can never enter the room when you're sitting as a mediator. Strong quads for positive steps. You have to have a strong persona and a big foot for being firm on the ground. What it means is you have to be polite but firm. If this is the rule, this is the rule. I'm not going to shout or get angry or be rude. I'm going to be polite, but if I set rules, those rules have to be followed. Mediators does not uh, decide but helps air disputes, identify the strengths and weaknesses of the cases, understand the accepting less, and agrees on a satisfactory solution, and creates a safe space and trustworthy space for the parties to come out. Now, what does a bad mediator look like? When mediators are too passive and fail to bring proactive negotiation assistance into the dialogue. When they try to move things around by bullying or judging the parties or the issues. Now, bullying is something which you don't think might come outrightly, but as a mediator, if you are saying, oh my God, you are unable to even resolve this issue, oh my God, this is such a small issue, you're sort of looking down and you're sort of pushing them to resolve it. See, if you do that, even if they come down to a settlement agreement, they will not be happy, and there's a 100% chance that they are not going to abide by the settlement agreement, and the entire concept of mediation, where parties voluntarily come to a settlement, will not be happening. And so it's going to be a complete failure of the process. Okay, so please don't do that. Knowingly or unknowingly, do not bully or judge the parties or the issues. Okay, people often misjudge just how professionally skillful a mediator needs to be. They think they can use like a former judge or a diplomat or some family business cases as a trusted advisor, but training is important. Okay, this is not to demean any profession, but if one wants to be a mediator, a mediation training is important. There are countries, I think it was Sweden, if I'm not wrong, and they basically had this thing where a sitting judge would first act as a mediator, and if it doesn't resolve, then they will act as a judge in the same particular case. When they're doing it, that is not mediation. In China, I went there and I saw this. They have this cyber court concept. Okay, and it's a building which is a 15-story building, and there are only 5 humans working there. Rest everything else is controlled and managed by robots. So there they have mediation which is being taped. If they do not resolve through mediation, they are taken to the court, and in the court the judge actually goes through those mediation tapes, and then they see what is happening, and then they give their judgment based on that. So that is not mediation. Okay, so no matter however expert or whoever expert you are in your particular field, to be a mediator, you have to be trained with the skills of a mediator. Okay, and this is something where we sometimes end up lacking. Uh, but I mean, we are definitely making progress in that, and I'm so glad that this is happening, because it is very important for everybody to have at least a basic skill set training, which is why this 40 hours training, and which is why in India as well you have a compulsory 40-hour mediation training to become a mediator, and I think it is very important. Okay, so otherwise it's going to be bad. Now, what are the skills of a mediator? Establishing transparency, maintaining neutrality, excuse me, managing emotion. As I said, you cannot sideline emotion, you can't throw them out, you can't put them on a break, you have to manage emotions. Building trust and rapport. Okay, and it is very difficult. You have to show empathy, you have to be non-judgmental, you cannot interrupt, you have to actively listen. I'll tell you what, honestly, active listening, if you can do proper active listening, that is the best way to create trust and rapport. If you are a good listener, I met with a client. I'm recently dealing with a divorce case, and when I met with the client, I was doing some pre mediation counseling. I was trying to get this into practice. So they are both husband and wife. They are both doctors. Okay. So when I met the husband, after we finished having the professional conversation, then he was just asking me about my profession and what I do. And so he asked, "So you are a counselor?" I said, "No, I'm not a counselor. I'm a lawyer." He was actually astounded. He's like, "I have never seen a lawyer sit and listen to a client speak for these many hours. I mean, how? Are you sure you're not a counselor? You've never done counseling?" And I was like, "No, I'm not." So active listening, and that is when the person really like could understand that, okay, this person is listening to me, and this person is, I can trust somebody like this. And that's how it went. So they haven't even gone to the court, and the husband actually convinced the wife to come for mediation. So it's a good thing. Okay, so actively listening, being silent and being patient is one of the easiest ways to actually gain trust. Okay, facilitating collaboration. So instead of thinking, "This is my problem, this is the solution I think it is," instead of thinking like that, if you start thinking on, "Okay, this is what I think is the problem, this is what the other person thinks is the problem, this is what the actual problem could be, and this is how it could be solved." So instead of having A against B, you can have AB against the problem. Okay, so that is how you collaborate, and that is what the mediator's job is to. Now, steering parties towards shared goals. If you have goals which are to be, so it shouldn't be like one has done the wrong and the other is just supposed to, compensate or pay the liabilities. Not like that. Both of them should be having some point to, make things better in the future. That should be the approach and perspective. Deep listening. As I said, active listening, very, very important, and taking the pulse. Taking the pulse is just basically developing skill set and being intelligent in the mediation room. Okay, the moment you see that somebody is just, as I said, you might have clients who are like cry babies. They'll just come to crib and cry. They don't want to solve it. Okay, they don't even have the aptitude to solve it. They just keep on saying. So if you feel somebody is like that in the room, there's no point of doing this mediation. So you, after a point, you sort of break it and you say, okay, maybe you can suggest them to get the lawyers on board. Maybe the lawyers would be more intelligent and practical, and maybe the lawyer will help the client to actually solve this. So what is going to be your next tactic? Studying the room, what is going to be the next step, how to break this, how to take care of it, all of this is like understanding the pulse, and for all of that you need loads and loads of concentration and patience. Organization and time management, very, very important. You should never schedule a mediation when in the first half, when the other half is already preoccupied. So for example, if somebody has a meeting at 3, you should not schedule a mediation from 11 to 2, because with all probability, right from 1 to 1:30 p.m, the party who has a meeting at 2 o'clock will from 3 o'clock will start in his or her head that, "Oh, I have to go and I don't know what," and all that. So the person will already be distracted, physically present but mentally not there. So you have to be very calculative, and you have to be very very sharp in also scheduling that. Okay, a mediator knows how to avoid time wasting traps and keep the process on track. A lot of times you will see that clients just want to sit there and waste time. I don't know why. This actually happens a lot of times. I've seen that they end up talking about something else only. There's a husband and wife having their dispute. Suddenly the husband starts talking about the wife's cousin and what she did in their wedding and all that. is not relevant. It's not even important. It's not related to the issue, even the least. So when you see that the person is deviating a lot of times, you understand they are just wasting time. So you stop it there and you sort of channelize it in another direction. And that's that. So that is my presentation for the role of a mediator. I know it's a lot of information to take in, and it's going to take a lot of time for everybody to get how complex and how easy at the same time this thing is. Mediation is a wonderful process. It's a magical process. There are countries like Spain, which sort of made mediation compulsory. So the government said that if you're going to go to a court, you have to first go to a mediation. You have to take minimum 2 sessions of mediation. You don't have to compulsorily settle, but you have to take 2 sessions of mediation. And after that, if you think this is not working, you can obviously leave and come down to the court. And what that led to is, after 3 to 4 years, now they have more private mediation setups than they have courts coming up. So it is something which is very important. And I'm glad. Thank you so much for being such patient listeners. I hope I could discuss at least some important aspects of what this is. And yeah, that's pretty much my presentation. Thank you so much, everyone. Thank you, Goswami sir, and thank you, Justice Ali, for being there. I think Ashadi can take over. Thank you.
আমরা কোনো কি প্রশ্ন করতে পারি?
Absolutely, sir.
Dear friends, would you like to any question to put?
If any one of you wants to ask a question or maybe make a point, you had an observation and you want to share something that you learned or anything.
Lordship, আমরা proceed করব next.
Yes, everybody seems to have understood everything and got everything right. So yes, let us proceed.
এখন আমাদের যে 6টি গ্রুপ করা হয়েছিল, এই গ্রুপ আজকে ডের উপরে যে মেডিয়েশনের উপরে যে আলোচনা হলো তার উপরে সংক্ষিপ্ত কিছু বলার জন্য এখন আমরা অনুরোধ জানাচ্ছি। Group 3 leader.
Dear moderator, I think you can hear me. Am I muted?
Yeah,
Can you hear
yeah,
me?
yeah.
Okay. Thank you very much. Here our Chief Trainer, Honorable Justice Muhammad Iman Ali sir, and Honorable District and Session Judge of Sirajganj, Mr. Fazle Khuda Muhammad Nazir sir, today's learned resource person, and all the participants here. Assalamu alaikum and good afternoon, everyone. I am Simon Al Islam, an assistant judge from Sirajganj District and Session Judge Court. Thank you very much for asking me to summarily discuss today's whole session. Before that, I must say this is a very much comprehensive, exhaustive, and effective session today. Enormous gratitude to Madam Priyanka Chakraborty for appearing before us with a smiling face, even after a closer one has passed away very recently, as we have come to know. Deepest condolence from Bangladesh for you and your family. May God rest your soul in peace. I have made some notes for myself. In the light of these notes, now I am going to talk about today's session briefly. Please do forgive me if I am mistaken. Today's in a first half of the session, we have learned exactly what the process of mediation, the stages of mediation, and role of mediators. Today, there we have discussion on how to get prepared for mediation. We have come to know that mediation process can start with introduction, then understanding the problem of the parties, then understanding the parties, defining the problems, creating and evaluating options, and settlement. Madam Priyanka Chakraborty has shared a divorce and child custody case she is dealing with nowadays. She has also shared some other mediation cases in the light of her experiences. She has also elaborately discussed went to mediation process, reframing solution, parties' position and interest. What is position? What is position? What is the position and what is the what is position and what is the difference between interest and position? How to let parties speak about their interest, not position. In example, she has also laid down the famous orange story and another story called window opening story. She has very rightly said that position is very strict. How to find out parties' position and interest, and how to creep toward the interest from the position of the parties for the best probable solution. While talking about steps of mediation, she kept convening the mediation process as number one, then initiation of mediation process, then setting down the agenda or framing the issues, then facilitation of negotiation, and the generation of options, reaching the mutual settlement, and finally closing the case. About the roles of mediator, we have come to know what the mediating lawyer should and should not do. Sorry.
You carried
I
on,
think-
friend.
We have come to know what the mediating lawyers should and should not do. Our research person has come up with some very practical difficulties what lawyers may subconsciously or intentionally create in mediation process. It has also been discussed what a mediator should or should not do, like being patient, listening attentively, being genuine, understanding the case, keeping control, not lying, being silent, not blaming, not using phone, not being emotional, not imposing on decision, and so on. We have learned what are the bad types of mediation. We have also witnessed a discussion on the general guidelines of mediation. We have a glimpse of Batna and Watna today. Why should mediator be silent while in mediation, etc. We have come to know the role of mediator, role of lawyers, role of parties, and some other important aspects of mediation, what a mediator should highlight on. Some ground rules of mediation that should be explained by mediator, when and how to open a joint session, what are the objectives of a joint session, why, when, and how to arrange a private caucus and its objectives. At the end of the first half of the session, we got a given problem. We have an elaborate discussion on it on second half. We have learned how an opening statement of a mediator should be. We have also been evaluated by marks. That was also very interesting. There we witnessed a discussion on how a mediator's behavior and demeanor should be, which action and behavior will make the parties think the mediator is biased. Madam Priyanka has had a great and elaborate speech on what are the duties of a mediator, roles of a mediator, what are the necessary attributes of a mediator, what does a bad mediator look like, and finally, which are the skills of a mediator. And that's all what I have managed to summarize today. Thank you very much.
Goswami sir, we can't hear you. You have to unmute the mic, I think.
Sorry, sorry, madam. Now we welcome Asha Mahant to speak the third day, that is day 3. Summarize the day. Asha Mahant.
Thank you, Dada. Thank you, Ms. Priyanka and Mr. Simon Al-Islam for summarizing actually for the detailed session and for the summary. Most of what actually I wanted to say has already been captured by Mr. Simon. But nonetheless, I'll try to summarize whatever slides I have prepared. First and foremost, my heartfelt condolence to Ms. Priyanka's family for the irreparable loss. It is commendable, Priyanka, that despite such tragedy, you could conduct to this session. I mean, I cannot even imagine how difficult that would have been for you. Priyanka, that was indeed an elaborate and exhaustive presentation. You put in a lot of effort to simplify the concept of mediation and the related aspects to all of us today. I actually have no doubt in my mind that everyone who has paid attention to your presentation has learned a lot today. Nonetheless, so as to refresh everyone's memory, I have been asked to again summarize the entire session. So here we go. Ms. Priyanka's presentation consisted of 3 topics: the role of mediators, the process of mediation, stages of mediation. So now I'll quickly take you through her points so that you can capture the entire session in case you have missed out on anything. For this purpose, I have simultaneously prepared slides out of a presentation, which now I'm going to share. And I request you all to take screenshots of the same for your a ready reference. So just a second. Can you see my slides, please? Is my slide shown?
No, no,
Hey,
no.
No, ma'am,
Okay,
actually it is buffering.
okay, 1 second. It's paused. 1 second. Wait.
perhaps you could share the slides on the
I
chat
am
box
here.
so that
Yes,
we can see it in
Yes,
our
sir.
spare time in the evening.
Okay, sir. Just give me a second, please. Is it visible now? Yes.
Yes.
Okay.
Yes.
Okay. So here are some slides that I have prepared while Priyanka was discussing the subject. So in the beginning, she has discussed about the process of mediation. And what is mediation? An alternative method of resolving disputes without going to the courts. The structure is, it is a structured, voluntary and interactive negotiation process where a neutral third party uses specialized communication and negotiation technique to help the parties in fulfilling their stated objectives. As a party-centered process, it focuses on the interests, needs and rights of the parties. Now, what is the process? A role of the mediator in the process is both facilitative and evaluative. A mediator facilitates when he manages the interaction between the parties, he encourages and promotes communication between them, and manages the interruptions and outbursts by them and motivates them to arrive at an amicable settlement. Like she was saying that if the topic is being digressed, he channelizes the entire discussion and brings them back to the talking table. A mediator evaluates when he assists each party to analyze the merits and claims defenses and to assess the possible outcome. Basically, this happens in the caucus sessions when the mediator will go meet the parties separately and probably without being assertive, try to sort of, take them through the pros and cons of the positions that they have taken. A mediator employs certain communication skills and negotiation techniques to facilitate a productive interaction between the parties so that they are able to overcome negotiation impasses and find mutually acceptable solutions. What is the process of mediation? She explained then in very great details that mediation is a voluntary participation. It actually brings the parties face to face to discuss their conflicts. The parties get an opportunity to understand each other's point of view. Certain times it so happens that the parties are not on talking terms with each other, but since they're sitting across each other, they get a chance to vent their feelings, to understand where the stand is, what position they have taken, and why the impasse has come to this stage that now they have to either litigate or mediate. So all this relevant information is being shared, and probably after they went out their feelings, maybe a shared agreement on equally mutually agreed terms can be facilitated between the warring parties. So this is the basic characteristic of a mediation process, getting the parties to sit in the same room across each other. Now, who's a mediator? Mediator is a neutral third party He remains impartial, independent, is detached from the proceedings, and is objective throughout the mediation process. He is not adjudicating, he is merely assisting the parties to talk to each other, take them through a guided process so that they can understand their particular stand and they can find their own solutions. The most important is the mediator does not find any solutions for the warring parties. Mediator merely takes them through the process where the parties, after venting their feelings, maybe can see, as she said, from the given example of the mother with 2 kids with 1 orange to share. So probably when you ask questions, you understand why a party has taken a position, but to understand the underlying interest. And when the mediator shifts the focus to the underlying interest, probably the party starts seeing the conflict in a different light and probably try and find creative solutions. So that is the main quality of a mediator. Without asserting himself, without asserting his views, he just takes them, shifts their focus from the position to the interest. Now, a mediator has to have certain specialized communication skills, and he has to have negotiation techniques to facilitate a productive interaction between the parties. This happens in the joint discussions as well as the private caucus sessions that the mediator has with these parties. The mediator will evaluate how he can assist each party to analyze the merits of a claim and defense without, of course, again, putting any ideas of his in their own minds. So he will just keep asking relevant, pertinent questions so that the parties do start seeing the conflict in a different light. That's the very important role of a mediator. Now, what are the duties of a mediator? As explained, the 4 characteristics a good mediator has to bring to the table is that mediators should be able to quickly build trust and confidence. Taking Mr. Shaha's that opening statement example, as Ms. Priyanka pointed out, that saying that I have read your work or I'm impressed with your work or you're a literary, a genius will maybe dilute this first particular characteristic. So therefore, the mediator has to maintain impartiality, has to show unbiased nature, doesn't have to communicate whether he knows somebody or he doesn't know somebody. So basically, he has to project that he is an absolutely impartial person. He's trained mediator and he's only here to assist the parties through a guided process in accordance with the principles laid down by law. Also, when he talks about the ground rules in a mediation room, so that is how he communicates to the parties that he is in control of the entire proceedings and he is able to guide the parties so that they can trust him and they can have confidence in him without, feeling that he is biased towards any one person. Well, having patience and a sense of humor is an added cherry on top. He has to be creative in assisting parties and give counsel in shaping a solution through a guided process in a very neutral way. And also his reputation in the legal fraternity will count a lot in making him trustworthy or not. Now, what is the role of a mediator? So at the first meeting, as it's been explained before, and Mr. Saiman also repeated this, and we've already done, the opening statement exercise. So what happens is in the first meeting, the mediator will, request the parties to sign jointly with him a center's model mediation agreement. At least in India, we do have this kind of an agreement where the parties agree to mediate, but it doesn't mean that they agree to settle. So there is a binding mediation agreement that we will sit to mediate, wherein it is again made very clear to them that it is a voluntary process. You're not, even after signing this, it is not that you cannot leave the mediation proceedings and walk away. It is parties have the right to self-determine till what time they want to continue with the mediation. Then he will give a brief description of his role and of the parties, explain the mediation process with whatever statutory provisions prevailing in that country, discuss with the parties whether they agree to give the consent in writing, him or her to hold separate caucus sessions, and whether to share confidential information that he has obtained in a caucus session with the other party, and invite the parties to give a brief account of the facts of the dispute from their perspective. This is most important so that, as we said before, the parties, when come to a warring table, they have a particular position in their mind. When they start talking to each other, the mediator will take them from that position to the underlying interest. That how does it help you, or why would you want to do that? Pertinent questions in a very guided manner will make both the parties see their points of view from a different angle. And probably the perspective will change and settlement could be in the offing. What are the attributes of a mediator? Attributes, the 4 characteristics a good mediator has to, I think I've already said this, that he has to create trust and confidence, and he has to have interpersonal skills, etc. Now, what are the other attributes? Are alertness, patience and tact, credibility. Alertness is, of course, when he's sitting in the mediation room, it's not only that he has to be physically alert, as she said, that there should not be a chair with a revolving, wheels, or which is distracting or disturbing others. But alertness here also would mean listening to what is not being said, listening to what is the underlying fear of the party. So if he does that, then he will be able to sort of, guide the parties to a better amicable settlement. He has to be patient and very tactful, and maybe change tactics, as she said, when he sees that there is an impasse, maybe he would want to involve outsiders, the councils, or maybe he'll take some time off, or he will try and change his tactics to see that if the temperature in the room is reaching very high, and the parties are hurling abuses at each other, then maybe take a short break, offer, as Justice said, some chocolates to somebody or something, some tact, he'll have to show, and get the entire process again under control. Also, he has to present himself in a believable and consistent manner, and follow through on any promises made, as well as never to promise what cannot be delivered. So like in a rape case, or in a criminal case where mediation is legally not possible, he cannot be sitting there and saying that no problem, you can mediate, you can, we'll decide the compensation and this is how this will be done. No, that cannot be done. So there has to be, within the mediation has to be conducted within the framework of the law of the land, and in such a manner which is legally enforceable, and it's not just done for the sake of doing it. A mediator who becomes easily discouraged by opposition or non-cooperation or other difficulties will not aggressively pursue the matter to a successful conclusion. So therefore, perseverance is another virtue a good mediator must possess. His appearance and demeanor has great influence on the conduct of any mediation, and the parties actually take him seriously if they see that he is, a credible person. If you see the mediator sitting on his phone, whiling away time, or when you're talking, when a party is trying to have an eye contact with the mediator, he's looking here and there. So then the parties start losing confidence. They start thinking, that the mediator is not with them. So the attentiveness, the appearance, the personal appearance for that matter, you cannot just walk in wearing a casual shirt and, sports shots or something and just show, you're here just to while away the time. No. So all these things, even personal appearance, as well as his conduct and his mannerism, everything is required to give parties confidence that this person is here to help them, guide them, and, make them reach some solution. So his appearance and demeanor is another attribute which is very important. Now, the mediator also, because if he is attentively listening, then only he will be able to grasp the initiative. If he sees that there is some opening, which he sees in both the parties' stands, and if he sees that there is an opening here, then that is where the mediator will have to grasp that particular advantage and probably, take them through that, discuss it more, elaborate on that. But it doesn't mean that he has to impose himself or dominate them, himself physically on them and say, no, just now you said that. Why don't we discuss that? No, not that way. He'll have to be very tactful, very diplomatically. He'll have to find some kind of midway, or some kind of creative way to break the impasse. So attention, perseverance, initiative, all these are the attributes which a good mediator must possess. And again, a good mediator is the one who understands his role, is competent, and he does what they say they will do. He needs to be trained and competent, of course. He needs to be trained, as just now Ms. Priyanka said. She gave the example of China and Sweden. So that is not the way a mediation process will ever work. So a mediator needs to be trained in proper mediation, and mediation advocacy also courses are available. So probably, it helps a mediator to be a good mediation advocate, and thereby he can become a good mediator also, because he will understand both the positions of the party as well as sitting himself as a mediator on the other side of the table. So a good mediator needs to be trained, and and unless they are trained, they cannot facilitate a fair process. What is a bad mediator? Everything that a good mediator is not, obviously, is a bad mediator. A bad mediator lacks listening skills, is biased, or allows bias to cloud discussions. He lacks patience, is either too forceful or not forceful enough in leading the discussions. So, for example, it allows the conflict to spin out of control and parties take over, and is just sitting there helplessly, not knowing how to control the entire process. So that's a bad mediator, and therefore mediation training is most essential. Then she spoke about the mediation skills. What are the mediation skills? Mediator has to establish transparency, explain all the stages of mediation process involved, etc., set up the ground rules, set agenda, and this way he can say, in addition to being transparent, he can assert his authority and let the people know that he is in control of the process. Second important skill is maintaining neutrality. It's easier said than done. Nonetheless, he has to be very careful not to take sides or sound gender biased or caste biased or anything like that. So he has to be very careful in this. Managing emotions, self-control. Yes, a mediator who cannot exercise self-control cannot be said to be neutral. He has to build trust and rapport, which is again a very crucial skill required from a mediator. This he can do by being non-judgmental, non-interrupting when parties are talking. He also has to be very patiently listening unless there is a reason for him to interrupt and take over. He should not allow abusive or aggressive language in his room. He has to facilitate collaboration. Like Priyanka said, it's not party A against party B, it's party A and B against the problem. So the collaboration is something that the mediator will have to see, how he brings both the sides to look at the problem from the same perspective so that they can find solutions. He can act as a guide and facilitator. And accordingly, likewise, he can steer the parties towards shared goals. When they start seeing the problem from the same perspective, then probably a shared goal can be, projected in front of them, which is a win-win situation for them. Maybe, party will have to take one step forward and the other one will have to take one step forward. But this will only happen when there's a collaboration. Otherwise, both parties stuck on their particular stand, it will be a deep impasse and the mediation will fail. Deep listening, as we already said, that deep listening is something which is not being said, which is not, unsaid. So if he understands the underlying interests of the parties, then probably he can be a good mediator. And taking the pulse, whether time to change the tactics or to continue on the same path that they are doing it. I think the last topic was stages of mediation. So there were 6 stages that Priyanka has discussed. Mediator's opening statement, opening statements of the parties, setting agenda and joint discussions, private caucuses, joint negotiations, and closure. Let's quickly go through these without taking much time. Stages of mediation would be what? Mediator will opening statement, again, he'll introduce himself, etc. We've already done this exercise, so I'm not going to really go on, discussing about it. He'll express hope that the dispute will be amicably resolved, and he'll request the parties to introduce themselves and their counsels, if any, sitting over there. Now, what is objective? Objective is basically of this opening statement and first session is to establish neutrality, to create an awareness and understanding of the process, to develop a rapport with the parties, gain confidence and trust of the parties, and establish an environment that is conducive to constructive negotiation and establish control over the parties. So that is the main objective of stage 1. Stage 2 is opening statements. Now, after mediator has finished his opening statement, he'll invite the parties as there won't be, he will not be deciding whether this party will speak first or that party. He will just leave it open to them. Whoever wants to, start with their opening statement. So the party, whoever chooses to speak first, will talk about whatever their disputes are and what are the consequences suffered by them, or what are the solutions that they're seeking. So the parties will have their opening statements in stage 2. After both the parties, mediator has had his opening statement, parties have had their opening statements, the mediator will now invite them for a joint discussion. He'll encourage the parties to respond directly. As it's been said time and again, mediator will try and talk less. Their advocates will try and talk less. It is the parties who will be encouraged to speak constantly with each other. So, but unless, of course, yes, as she said, that if a party is, medically unfit, or if she's unable to communicate and they've given the authority to their lawyers, then the lawyers will take over. Otherwise, the parties will speak to each other, and the mediator will effectively try and manage the interruptions and outbursts. There will be certain, emotional outbursts by the parties. Everybody will be hurling accuses at each other. Mediator will first, in this joint discussion, the main thing is that mediator will allow them to vent out their feelings, but at the same time, under controlled circumstances. Not that the parties should come to blows with each other, but yes, he will allow them to just take it off their chest, whatever it is. So then they will ask pertinent questions to elicit additional information. So which he feels have not been really identified or understood by all present. Then he will summarize the facts. This is most important. The mediator will, after hearing both the parties, will summarize the facts as understood by him. so that the parties again hear what they have said, what they have communicated, and what is being understood by the person sitting across them. And this also gives the parties an equal chance to actually consider, is that what really I said? Is this what I really want to say? Is this how it got understood? And maybe then they will, somewhere they will say, oh, no, this is not what I was trying to say. So probably they will start, introspecting. That is the most important, characteristic a mediator employs in summarizing the facts. We take it generally very, lightly that, okay, fine, you said something and I'm summarizing. No, there is a deeper meaning behind it. So this exercise, when, we were also doing the mediation training, this really helped, in understanding to when like role plays were happening and we were the warring parties, and when the mediator would say something and we'd say, no, this is not really what happened. So the summary of the facts is most important. And this is where the mediators, all skills, attention, the deep listening, all these skills, the tact, everything is, tested. This is a litmus test for the mediator. After that, what happens is you have private sessions, caucus sessions. So each party will meet the mediator privately, even if a party says, no, I don't want to meet you, but the mediator must, at least make an attempt to meet them so that none of the parties feel aggrieved. Then why did he not meet me, or why did he go to meet that person? So both the mediator must have these caucus sessions in separate rooms with both the parties. And he will go between the two rooms to discuss the strengths and weaknesses without giving his views, of course. And after they have heard the summary, and after they have sort of started introspection, maybe in the private caucus sessions they do try and think, oh no, this is not what I should have done, and maybe I want to resolve my dispute this way. So this is how the caucus sessions will help the parties. And after joint negotiation, it is actually unusual that the mediator brings the parties again for a joint negotiation, but there could be some exceptional circumstances where the parties would want to have a joint discussion and probably discuss some settlement terms, but generally it doesn't happen so. So the last stage of mediation is closure. If the parties, then there could be only two scenarios: either the parties agree to settle their dispute, or they don't agree to settle their dispute. If they agree to settle their dispute, then it is recorded in writing. Both the parties are asked to sign, and the original signed agreement is sent to the referral court, if any, or otherwise it is enforced as a contract. And if the parties don't reach, well, then the mediator still, gives them an idea whether would you want to meet again, or would you want to continue negotiations, or what. So he will not be absolutely, pessimistic and say, oh, okay, now your negotiation has failed, mediation has failed, please see each other in the court. No. So mediator will still try, and say that whether it will be fruitful to meet again later or continue negotiation by phones. Now, I think I'm just taking this a little one step ahead. I think Priyanka would have wanted to speak about this. What are the techniques used in negotiation? The techniques negotiation is to consider the different alternatives to a negotiated settlement. Priyanka, would you want to take over, or is it okay if I just quickly read through this slide of mine?
No, please go ahead.
Sorry, because yesterday the presentation you shared with me, I had seen this, so I just sort of made a kind of a slide on it. You
Right.
can obviously add to it later on. I'm just going to quickly read through this.
No,
I
right.
think I've taken enough time also. So one of the technique of reality testing used in the process of negotiation is to consider different alternatives, which is known as Vatna, Watna, MLATNA, etc. What is Vatna is the best alternative. Okay, so best alternative to a negotiated agreement, worst alternative, or most likely alternative to a negotiated agreement. And also then there is something known as a zone of possible agreement, which is, like there is an, I just taken an illustration. There is an engineer who's looking for an annual salary of 50 lakhs at available desirable job. He may have following alternatives. Either have a higher salary at a less desirable job, less salary at an equally desirable job, or staying put and waiting for a better offer. On the other hand, a company which is looking to give 75 lakhs salary to a candidate, they may have following alternatives. Give higher salary to a less desirable candidate, less salary at an equally desirable candidate, or staying put and waiting for a better candidate to come forward. So in this case, a zone of possible agreement could be perhaps the company and the engineer can negotiate for a salary, between the range of 50 to 75 lakhs, whatever the gap is, and so that they both have a win-win situation. So these are different ways of, the techniques that you can use in evaluating the different solutions. So probably a mediator can assist the parties, take them through while guided speech and ask them to consider what are the options available to them and what would be the best alternative according to them. Because this is not an ideal world we are living in. So it's not that, that whatever the party wants is always what they're going to get. So therefore, probably the mediator can just, guide the parties and tell them that these are the, consider what are the options available to you and probably find a zone of possible agreement. So I think this almost captures everything that I have been able to take from Priyanka's session. And thank you very much, everybody, for your patience and listening to me. Priyanka, I think you can take over now in case they have any questions to ask you. Thank you.
Thanks, Asha Mahant. Thanks, Madam Priyanka Chakraborty. What we learned today, I think we learned in one sentence how to prepare ourselves before mediation. Another thing, one question put to you. Learned friends, would you like to speak anymore regarding that question or anymore? Or Priyanka or Asadi? Anymore? If no, then I request His Lordship, Mr. Justice Muhammad Iman Ali sir, to conclude this session.
Thank you, Mr. Goswami. It has been a long day full of information, full of ideas. I hope everybody will have learned a great deal from the very comprehensive stories that Priyanka has told us, as well as how to deal with situations in the mediation. So I don't want to, Asha has kindly told us in brief what Priyanka said. So I think you should all be clear. I hope you will all be clear on what to do and what not to do during the preparation for mediation and during the mediation. There is another day tomorrow. As I said previously, all mediators are not the same. Each mediator will have his idea of how to deal with the situation. Equally, you will not be same as your colleague. But what we want you to do is to learn from each and every one and decide in any particular case that is in front of you, how to deal with it. And the art of dealing with the mediation, the case in front of you, in the best possible way, that is the art that you have to develop. And that is something that you will develop over months and years of experience. And I wish you all the very best. Now, before I finish the problem that I gave you, if anybody is interested, I will tell you the answer tomorrow. Yes, I can put some dates to the problem. And the year of the agreement was 2016. And there is one other information which I forgot to give you, and that is that during that period of 4 years lapse, the parties did communicate. One party said, pay up, and the other party said, I'm in difficulties now. So after the 4 years, one party paid, the party A paid, in fact, 2 lakhs more out of the 7 lakhs remaining.
So it is not time barred. So it is not time barred.
So no time barred. That is the issue. That is the issue, not time barred. They paid 2 lakhs and it was accepted. So question of time is not there. So in 2020, they paid 2 lakhs, accepted 2 lakhs, and then the problem arose. So I will tell you more about what I did, not as a mediator, but as a, if you like, a go-between. But that is for tomorrow. I think for today, we have had enough. We've had a long day. I wish you all the very best, and we will see you tomorrow morning. Mr. Goswami.
Yes, Lordship, thanks to you and also learned friends. Today's, I think, our session, that is today, day 3, concluding successfully, is my understanding. Yes, welcome. Thanks all of you.
Thank you.
Thank you, sir. Thank you, everyone. Have a great day ahead.
Thank you.
Yes, Priyanka, thank you. Yes, Asadi, thank you.
Thank you very much. Thank you, Dad. Thank you very much. Good day, everybody.